Welcome to our new video. Today we are going to discuss some important aspects of the trademark process, including what happens after a trademark hearing, the timeline for filing an opposition, and the types of evidence required during the opposition proceedings. If you're involved in trademark registration or facing objections, this video will guide you through the next steps clearly and simply. Question 91. What happens after trademark hearing? Answer. After the trademark hearing, where the applicant is given the opportunity to present their arguments, evidence, and respond to any concerns or objections raised by the examiner, the hearing officer will make a decision. Key points. The hearing officer will carefully review the applicant's arguments and any supporting evidence provided during the hearing. A written order or decision will be issued by the hearing officer, which can either be approval. If the concerns or objections have been satisfactorily addressed, the trademark application may be approved. Rejection. If the objections are not resolved or are deemed insurmountable, the trademark application may be rejected. This decision will then move the application forward in the process, either toward registration or further legal action, if necessary. Question 92. What is the time period for filing the opposition? Answer. A notice of opposition must be filed within 4 months from the date of publication of the trademark in the Trademark Journal, in which the trademark application was advertised. Key points. The 4-month period begins from the date of the publication of the application in the Trademark Journal. If no opposition is filed within this period, the application may proceed towards registration. It's important to be aware of the timeline to ensure that any objections are raised in a timely manner. Question 93. What is evidence in support of opposition? Answer. The opponent must file the evidences in support of trademark opposition within 2 months of receipt of a copy of the counterstatement, or shall intimate to the registrar and to the applicant in writing that he does not desire to adduce evidence in support of his opposition, but intends to rely on the facts stated in the notice of opposition. Rule 45 of Trademark Rules 2017, within 2 months from service of a copy of the counterstatement, the opponent shall either leave with the registrar such evidence by way of affidavit as he may desire to adduce in support of his opposition, or shall intimate to the registrar and to the applicant in writing that he does not desire to adduce evidence in support of his opposition, but intends to rely on the facts stated in the notice of opposition. He shall deliver to the applicant copies of any evidence, including exhibits, if any, that he leaves with the registrar under this sub-rule, and intimate the registrar in writing of such delivery. If an opponent takes no action under sub-rule 1 within the time mentioned therein, he shall be deemed to have abandoned his opposition. Question 94. What is evidence in support of application? Answer. The applicant must file evidence in support of a trademark application within 2 months of receipt of copies of affidavits in support of opposition or intimation that the opponent does not desire to adduce any evidence in support of his opposition. In case the applicant adduces any evidence or relies on any evidence already left by him in connection with the application, he shall deliver to the opponent copies of the same, including exhibits, if any, and shall intimate the registrar in writing of such delivery. Rule 46 of Trademark Rules 217 states that within 2 months on the receipt by the applicant of the copies of affidavits in support of opposition or of the intimation that the opponent does not desire to adduce any evidence in support of his opposition, the applicant shall leave with the registrar such evidence by way of affidavit as he desires to adduce in support of his application, and shall deliver to the opponent copies thereof, or shall intimate to the registrar and the opponent that he does not desire to adduce any evidence, but intends to rely on the facts stated in the counterstatement and or on the evidence already left by him in connection with the application in question. In case the applicant adduces any evidence or relies on any evidence already left by him in connection with the application, he shall deliver to the opponent copies of the same, including exhibits, if any, and shall intimate the registrar in writing of such delivery. If an applicant takes no action under sub-rule 1 within the time mentioned therein, he shall be deemed to have abandoned his application. Question 95. What is evidence in reply by the opponent? Answer: after receiving copies of the applicant's affidavit, the opponent has 1 month to file their evidence in reply. This evidence must be submitted by affidavit and should address the claims made by the applicant in their affidavit. Key points: the opponent must deliver copies of the evidence, including any exhibits, to the applicant. The opponent must also notify the registrar in writing about the delivery of the evidence and exhibits to the applicant. This process allows the opponent to present their side of the case and respond to the applicant's arguments before the registrar makes a decision. Rule 47 of Trademark Rules 2017 states that within 1 month from the receipt by the opponent of the copies of the applicant's affidavit, the opponent may leave with the registrar evidence by affidavit in reply and shall deliver to the applicant copies of the same, including exhibits, if any, and shall intimate the registrar in writing of such delivery. Rule 48 of Trademark Rules 2017 states that no further evidence shall be left on either side, but in any proceedings before the registrar, he may at any time, if he thinks fit, give leave to either the applicant or the opponent to leave any evidence upon such terms as to costs or otherwise as he may think fit. If you want to register your brand name, logo, or tagline and legally secure your identity, don't wait. Get expert help with the entire trademark registration process. Contact VMK Professionals, your trusted legal and business partner, to ensure your brand is protected under the law. Visit www.vmkpros.com and get started today. So that's it for this video. We hope you learned something new and valuable about the trademark process. Don't forget to share your experience or any questions in the comments below. We'd love to hear from you. And if you found this content helpful, make sure to like, share, and subscribe to our channel for more informative updates. Thanks you.